Good evening. This is John Milburn for Laws 12060 Trusts. We're in week 5. We are due to talk about the trustee, but we've been listening before we started to record to some excellent discussion about resulting trusts and constructive trusts. I acknowledge that they are not easy areas, and I think it's appropriate that we do revisit those. Perhaps not tonight, but we'll come back to those at some stage. All right, so tonight we're talking about the trustee. And in the Moodle site, you'll see that there are some flowcharts. There is a flowchart in relation to the trustees, and I'd recommend that you look at that. Now, I'm going to ask a question. Has everyone looked at the Trusts Act? Yes? We'll take that as a yes? No? All right. If you haven't, please do so. Because when it comes to trust law, a lot of the material is common law based, but I like reading statutes. I like the certainty that statutes provide, and so I'm relieved when we get to a stage where there is a section of trust law that is quite meaty in terms of statutory provisions. But remember, of course, that there are a few statutes that might apply in relation to the issue of trustees. Can you name a few for me? I'm just going to hand it over to you so we can continue with that discussion that I heard before we started to record. So what are the pieces of legislation that we might consider in the context of trustees?
Well, the obvious is the Trust Act.
Yes.
Is there a Public Trustee Act?
Yes, there is. Yes, there is. What else have we got?
You have Trustee Companies Act.
We do, yes. Have a look at that as well. What other pieces of legislation would be relevant for trustees and trusts law?
I think also the Competition and Consumer Act could come into it on occasion as well.
It could do, yes, it could do. Where else?
Conveyancing Act.
Do we have a, I don't know if we have a Conveyancing Act, Maria. Correct me if I'm wrong, but I'm not sure we do.
You have a Property Law Act.
The Property Law Act, yes. Yes, there's provision in there for statutory trustees to be appointed in relation to joint properties. What else? There's more.
Succession Act.
Yes, I was waiting for the Succession Act. Thank you. That's very good. That'll probably do us. So bear in mind, all those pieces of legislation may have a bearing on a legal problem that you have. Those of you that did Introduction to Law with me will know that I'm very keen on the sort of brainstorming and lateral thinking idea. So just because you're doing trusts law, don't confine your thinking to just the Trusts Act is the point that I'm really trying to make. And when you're considering a legal problem, then you may need to put in the Succession Act or the Powers of Attorney Act or the Public Trustee Act or the Trustees Companies Act. The consumer law perhaps may be relevant. The corporations law may be relevant. So think about these different pieces of legislation, and please don't be afraid to toss them in to your answer if you believe that they're appropriate. All right, just a little about the exam. The exam will be at the end of term, of course. It's an invigilated examination. I'm saying this because it's on my mind at the moment. The exam is worth 60% of the overall assessment. You have your in-class assessment worth 40%, which is the assignment. I forget that's when that's due. I think it's mid-May or thereabouts. Can someone tell me when that? I'm getting a nod.
11th of May.
11th of May. All right, good. 11 May. I've got the answer from a few. I'm glad that you're thinking about that. Make sure you submit your work on time. There are penalties, 5% per day if you're late. Back to the exam. So the exam will be in two parts. The exam will be Part A, which is worth 20%. And this is compulsory. You've got to have a crack at Part A. And it's a problem-solving issue. So you'll be given a factual scenario and you'll be asked to give an advice. Typically in trusts law, I'll normally ask you to give an advice. So the sort of thing that you're doing in class each week with the weekly problems will get you in good stead for the exam. Part A will be along those lines. Now, Part B, you'll be asked to answer 4 or 5 questions, and each one of those 4 questions is worth 10%. So you get 40 marks for Part B and 20 marks for Part A, which is the 60 marks for the overall assessment. All right, so you've got 5 questions. You select 4 of those, you answer 4. What happens if you answer all 5? What do you think the rule is? Only
the first 4 were marked.
Only the first 4. Do you think I'll even look at the 5th one? No, I've got too much to do. So I say that because every single time someone answers all 5 of them, but I can't broadcast it any more loudly than what's on the exam and what I'm saying now. 2 of the questions are essay style questions, explain the Trusts Act. It's not that broad, but that type of question, just a 1-liner or a 2-liner. And the other 3 are again problem solving questions where you're asked to extract the material and provide a response. How do you go about answering problem solving questions? Do you have a general technique that you follow?
Oh, you can use the acronyms we learned in with you first up, John.
Exactly. IRAC, MIRAT, whatever acronym works for you best. So definitely, that's the way to do it. I like MIRAT because I like to look at the material facts first. So as you're going through your examination, highlight the material words or extract the material words so that all the little red herrings that I tend to throw in, you can discard those. All right, so any questions about the examination? All right, good. Okay, well, let's talk about the trustees. So we know that the Trusts Act is very important. We know that trustees have certain powers, and we talked about those powers and how it all originated in medieval times with the Statute of Uses. But since then, trusts law has developed, and in the 2nd and 3rd week, we talked about commercial trusts, discretionary trusts, unit trusts, superannuation funds. So they really have a commercial flavour about them. So what we tend to find in trust law is the cases relate to relationships, and there's a lot of case law about people that were in de facto relationships, and also business type relationships where we've got commercial trusts. And I heard on the discussion before we came in, the discussion about resulting trusts and constructive trusts, a lot of that case law related to de facto legislation, which of course has now largely been superseded, if I can use that term, by the Family Law Act provisions, which incorporate de facto property settlements into the mainstream work of the family court judges and the Federal Circuit Court judges in exercising their jurisdiction over matrimonial issues. So a lot of that case law is now guided by other principles. But when it comes to commercial matters, we really see the role of the commercial trustees, and we consider the powers that are imposed. Look, what I'm going to ask you to do, if you're watching this live or you're if you're participating live or watching this later, if you've got access to the Trusts Act, probably a good idea because I'll be referring to it quite a bit tonight. The first thing that I want you to do is consider section 4AA of the Trustee Companies Act 1968. So we'll deal with the Trusts Act shortly, but I just want you to look at a few things in the Trustee Companies Act. So firstly, can anyone tell me what the Trustee Companies Act is really all about? What's it there for?
Well, I haven't looked at it, but I can only imagine where it's like if a trustee is a corporation or a company over a natural person, perhaps.
Yes. Okay, that's it. Thank you. So have a look at that. Have a look at section 4AA. When you see that it's got the capitalised AA, you know it's an amendment, and it provides for the powers of the trustees under that Act, if they're a commercial trustee, in addition to the powers that are generally provided under other pieces of legislation or the trust deed itself. So trustee companies have special powers, just be aware of that. Companies can act as an executor, they can obtain probate. Have a look at section 5. And one of the interesting things about section 5, it's actually mentioned quite a bit in not only this legislation but also the Trusts Act, is that the legislation applies whether the will, for example, or the trust deed was made before or after the commencement of the Act. So the legislation has a retrospective flavour to it. We don't see that very often. And that Act also provides for people to have trustee companies step into their place in terms of probate and administration. But I want you to read those sections, and this is where I said be aware of other pieces of legislation that are relevant. When you have a look at section 4AA, 5, 6 and say 20 of the Trustee Companies Act, I want you to read that in the knowledge of and in conjunction with the Succession Act, where there are certain provisions, and we'll talk about that a bit later as well. So the Succession Act applies in terms of trustee law, where we're talking about the administration of a will primarily. Okay, all good so far? Now let's go to the main Act, which is the Trusts Act, 1973. The Trusts Act is not a code, and a lot of the principles that are incorporated into the Trusts Act are based on English legislation, and that legislation is based on case law. But case law is still very important. So it's not a code, and I'm sure you all know what I mean by a code. Do you know what I mean by that? Who can offer an opinion? What's a code?
Codifying the
As in the criminal
statute.
Yes, the criminal code is a good example. So what's the purpose of a code? What's the intention?
It's supposed to state everything about the law. It supersedes any of the common law, whereas most of these acts are meant to be read in conjunction with the common law.
That's it. Where you see a code, you know that the intention is this is going to be the Bible, this is the main place or the only place where everything is. Of course, it never works. I mean, in criminal law, we have the Criminal Code, but we've got the Drugs Misuse Act, we've got various other Summary Offences Act, lots of other offences are referred to as criminal law, even though they're not in the Criminal Code. But that's the idea. So the Trusts Act is not a code, but it does provide a number of general headings. And when you're reading legislation, certainly from my perspective, what I always do is I try to look at all of the legislation at the start in a global sense. So what's the best way to do that? Can you give me a couple of techniques? You pick up some legislation and you want to get a feel for the entire legislation. How do you go about
Do you look at the object or purpose of the legislation?
Yes, I'm going to put that down as step number 3. But it's a good one.
Suppose that means the long and short title, and then look at when it starts, commences. And I'd like to go to the contents and just look at how many sections and roughly what they cover, and then before I start going into reading the bits.
Good. So looking at the contents, I think is step number 1. Always. I always do that. Look at the content, just look at the headings and try to absorb the headings and just get a feel for what is likely to be included in the detail from what's mentioned in the headings. It's really important. Second thing is have a look at the entire Act in terms of its content, its volume. Just get a feel for the Act. And have a look at, while you're doing that, you're just really skim reading. It's the first step, but you're going into a bit more detail. You're now trying to get a feel for the Act. You're looking at things like whether it does have an objects clause, or you're looking at the long title. You're looking for definitions. And the third thing, as Linda said, is I think you then narrow in on the purpose and the objects of the legislation. So once you've done those 3 steps, you're in a much better position to understand what this Act is really getting to. So when I look at the Trusts Act, I look at the headings and I'm particularly keen to see what are the parts and get a feel for those parts and say, okay, I think I know what will be in there. I don't know what the law says, but I've got an idea of what the law is going to talk about. So in the Trusts Act, the various parts are dealing with the appointment of trustees. You can have a look at the Trust Act if you've got it there. Investment of trust property by trustees. The general management and administrative power of trustees, that's part 4. The distributive powers of trustees, the power to apply income or capital for various purposes to beneficiaries, that's part 5. Indemnities and protections of trustees and the borrowing of claims is part 6. The powers of a court to oversee the administration of a trust, including the ability to make orders, to appoint and vest property in trustees, is part 7. Part 8 deals with charitable trusts and cypre schemes. Part 9 deals with gifts, and Part 10 deals with miscellaneous matters, including remedies for wrongful distribution of trust property. So even if you read those sections and you absorb it, you get an idea of where you're going to look first up if you have a problem that deals with those issues. So when you're dealing with a problem in trust law, try to identify the material facts, and then what do? We try to identify the issues. Right, first step, issues. And the idea of identifying the issues is we've then got something of a statement, maybe a phrase, and that phrase might match one of the headings of the parts to the Act. Okay, so if you're reading through one of these problems in trusts and you identify that a material fact is that a trustee is not distributing income in the way that the beneficiaries would like, then you think, oh, that's probably going to do with the distributive powers of trustees and their power to apply income or capital for various persons or purposes for the beneficiary. So that'll be in part 5 of the Trusts Act. Do you get the idea? Okay, so it's really important that you understand and absorb the headings and then drill down from there. Okay, having done that, Linda says, and quite rightly, we should consider the purpose, the object, and in some acts, and the Trust Act is like this, we need to consider the application of the Act. How does it apply and in what circumstances does it apply? And I'm really keen on this as well. Look out for a statement about which court we deal with in trusts matters. So I'm just going to digress for a moment. If you've got a problem in relation to a trust and you want to rely upon the provisions of the Trusts Act and you intend to apply to a court for a remedy, what court or courts can you approach to obtain the remedy that you seek under the Trusts Act? Any thoughts? And where would we find this information? For those of you that are keenly looking up the Act, have a look at section 5. Have a look for the definition of court. I do hope this is in section 5.
Yeah, it says Supreme Court.
Supreme Court.
Supreme Court.
Supreme
Yep.
Court.
We got a few people came in on the chat facility just before we heard it verbally. So thank you all for checking that. So what does that mean? What do they mean the court means the Supreme Court? I know that's a silly question, sort of, but what does that actually mean?
I guess that it has the jurisdiction to hear these matters.
Yeah, and I guess you could also read into that other courts, such as the District Court, the Magistrates Court, don't. It's a bit different when we come to the federal state sphere because there's the cross-vesting jurisdictions. Cross-vesting legislation from 1987 gives those comparable courts power to deal with each other. But in the state jurisdiction, where we're really talking, most of this stuff is state work. So we're really talking state legislation, state courts. We're really saying it's the Supreme Court. So if you read Supreme Court cases, you may find that there are monetary values that are less than you'd expect. Having said that, I'm going to refer you to district court decisions, so just to confuse issues as well. But it really does mean the Supreme Court. That's the starting point. Okay, have a look at Section 4 of the Act, and it will give you an idea of the application, the extent to which the Act applies. And I'll paraphrase it. So it says, except where otherwise provided, this Act, that is the Trusts Act, applies to every trust, as defined in Section 5, whether constituted or created before or after the commencement of the Act. So a couple of things there. The Trusts Act applies to every trust, but as defined in Section 5. So last week I said, what are the types of trusts that we've been talking about? We rattle off 5 or 6 different ones. What we need to do in this Act, for the Trusts Act, is we need to look at Section 5 and the definition of trust. So if you're following along, do that now. Try and find the definition of trust. And who can tell me what trusts the Trusts Act applies to?
Employed, resulting, bear, constructive.
Yes. Yep. And?
Doesn't include mortgages.
That's right. It doesn't include duties incidental to an estate conveyed by way of mortgage. You're not going to come across that very often. So leaving that exception aside, when we talk about trusts in the context of the Trust Act, we pretty much mean everything. It means implied trusts, it means resulting trusts, bare trusts, constructive trusts, cases where a trustee has a beneficial interest in trust property, and duties incidental to the office of a personal representative. Who's a personal representative?
That was a question I was going to ask, John. How does it differ from perhaps somebody who's a trustee?
Anybody have any thoughts on Erin's question?
The definition it gives of that means that the executor, original or by representation, or the administrator for the time being of the estate of a deceased person.
That's right. And I gave the thumbs up just before you spoke, Erin, and you gave the right answer. Melissa came in on the chat facility, so I gave her the thumbs up. And Adam's been very quick on the buzzer too, I noticed. So thank you for that, Adam and Melissa. Feel free to unmute your microphones if you want. All right, so let's assume that for all intents and purposes, the Trusts Act applies to all trusts, and that includes personal representatives. Personal representative is actually defined, isn't it? Can anyone see the definition of personal representative in Section 5? Correct me if I'm wrong.
Yeah, it does give it on page 10.
Okay. What does it say?
What I read out before, John, means the executor, original or by representation, or the administrator for the time being of the estate of a deceased person.
Okay, very good. Thanks, Erin. Yep. I didn't realise you'd found the definition, but that's exactly it. Thank you. All right, so it's very broad. Now, the Trusts Act applies, and tonight we're talking about trustees. So what is a trustee and what does it include? And I'll give you a hint. Let's have a look at the definitions. So do we know what a trustee includes? Okay.
Can be a person, trustee corporation.
Person, trustee corporation, other corporations, a personal representative, or a statutory trustee. And a trustee corporation is defined in the Act as well as being the public trustee or a trustee company under the Trustee Companies Act 1968. So definitions are really important. Yeah.
Oh, sorry. I was just going to say, how long have trustee corporations sort of been around?
Oh, I guess for a long time. I couldn't put a date on it, but you know, companies are very old institutions, and trusts are very old institutions. So I'm sure it didn't take them long to get together. Put it that way.
I thought I read somewhere that corporations couldn't, except for trustee corporations, couldn't be trustees for a post-mortem trust. Was that something like that? Only they said could only be legal person, natural persons. Is that
For a
no.
post-mortem trust.
I mean, like a will, like a testamentary trust. Is it? Except for special trustee companies.
Yeah, actually. You know, that's a really good point, B, because I have never specifically turned my mind to it, but you're right. I can't think of one instance ever where a company other than the public trustee or a specialist trustee company has acted in the role of executor. And if someone said to me, I don't want to appoint my, you know, a wife as the executor, I want to appoint my family company as the executor, my immediate thought would be, no, you can't do that. But I've never actually thought about it. So I'm sure that's right. So thank you. Was that something in the Succession Act?
I think it was in the readings, wasn't it, B? In our readings for this week?
It was in the readings for the week. Very good.
Yeah.
Thank you,
from the
Ben.
text.
Thank you, Erin. All right. You've all read more closely than I have. Thank you. All right. So trustees under the Act have certain powers, and the Act may confer upon those trustees more widespread powers than they have under the trust instrument. And Queensland's a little unusual in this regard, in that there are a couple of provisions in the Act, the Trust Act, that state that the powers and the obligations and the responsibilities which are conferred by the Act supersede the trust instrument. It doesn't apply in other states. We'll talk about a couple of those. So we understand now that sections, say 4 and 5, maybe 6, give us a feel for what is the extent of operation of the Act. We talked before about courts having an ability to review decisions. So have a look at, say, Section 8 initially of the Act. Section 8 provides that it's possible for a person to apply to a court to review acts and decisions. Which court? How do we apply? What acts and decisions is being talked about? Well, the detail, of course, is in the section. Section 8 provides that any person who has directly or indirectly an interest, whether it's vested or contingent, in any trust property, or who has the right of due administration in respect of the trust, or who is aggrieved by an act or omission or decision of the trustee, may apply to a court to review that act, omission or decision, or give directions in relation to the apprehended act, omission or decision. I'll just stop there. I've paraphrased that, but what that really says is that if you're not happy, if you have an interest in a trust and you're not happy about the way things are going, then you can apply to a court to review certain things. But
is that as a beneficiary?
Well, let's have a look at, yes, so as a beneficiary. So let's have a look at the definition in Section 8. It says any person who has directly or indirectly an interest, whether vested or contingent, in trust property, may apply to a court. So does that include a beneficiary? Is a beneficiary a person who has directly or indirectly an interest in the trust property?
Yes.
We're getting a few yeses. So I would say yes, a beneficiary. What do we mean by a person with an interest, whether vested or contingent? What does that mean?
Well, but isn't it where they like sort of pass title of the property to the trustee?
What was that again? Sorry, Tamara?
Isn't vested where they sort of ensure that sort of title or ownership, if you like, is passed to the trustee of the property?
Yes. So when you're vested, when you have a vested interest, you're saying that you have a present entitlement. I think is probably the term that I'm looking for. How do we distinguish that to someone who has a contingent interest? And what's an example of a person with a contingent interest in the context of trust law?
Is it like a will, or if you like a condition, you've got to do something before you can get it, or something has to happen before you're entitled to it?
Yes, that is, I think, probably a good way of looking at it. Any other instances of a contingent interest in trust law?
Gift, according to the definition, John, I'm cheating, in relation to land includes a contingent or executory interest and a possibility coupled with an interest, where the object of the gift or limitation of the interest or possibility is or is not ascertained, and also a right of entry, whether immediate or future, and whether vested or contingent.
That's excellent, Erin. Is that in section 5?
Yes, page 8.
I missed it. Well done. Good on you. Excellent. Always go and have a look at the definitions. It makes the job easier. I think in terms of a contingent interest in a trust, as a person who's a potential beneficiary in a discretionary trust, but who has not received the benefit of the discretion in their favour. So I think, let's say you have a discretionary trust, and the trustee has the ability at its discretion, or his or her discretion, to give funds to any one of 3 named beneficiaries as they see fit, and they choose to give it to 2 people and not the other one. Can the other one, the third person who didn't receive any benefit, do they have any right to go to court and apply for something? Yes?
No, I don't think so, because it's a discretionary trust.
Erin says no. Yes,
well,
Tamara?
maybe they can, but whether they'll be successful or not is another thing, because if the trust instrument has sort of said, well, one, it's discretionary, and like even if it went on further and said, well, it's discretionary in these other ways as well, tough bickies if you don't get what you want.
Yeah, I think that's right, Tamara. And I think the approach is, you can almost think of it this way. The court doors are open. They say, are you a contingent beneficiary? Come on in, tell me what you want. That's what you want? Now get out of here. No, go away. But at least you have the right to be there and make an application. It's a little bit like making an application under a family provision claim. If you're a child, for example, who didn't receive any benefit under a will, you would make an application, not under trust law, but you would essentially challenge the will by a family provision under the Succession Act. So it's the same sort of principle. Yes, you have a right of audience, you have the right to be here, but whether you succeed or not, that's a different matter. Okay.
John, is that like where they say you're contesting a will? Is that what they...
Exactly, yeah. So that, I was digressing then. That's not trust law, but it's something that, to my mind, is a similar concept. Yes, you've got the right of audience, you can put your foot in the door, but whether you're successful or not, that's a different story. That's a different part of the test. And we'll talk about that tonight as well.
Sorry, John, it's Grant.
Oh, sorry.
Yes, Grant.
Just a quick question. On the trustees, how often can they deny a beneficiary? Just for instance, I've got a friend who's funny enough to solicitor selling his house, and he had this funny feeling that the solicitor who wrote to him was the trustee for this young kid who was like in his 20s and wanted to buy his house, and the guy refused, said it wasn't a suitable purchase, and he wouldn't release it so he could buy his house. So he basically, the trustee at the front said, no, mate, I don't think it's a good buy. You shouldn't be buying it. I'm not giving you any money. Go away. How often can they do that?
Oh, okay. So I think what you're getting at there, if I've understood you correctly, Grant, is a situation where the beneficiary
he wanted to purchase a property, yeah, and he directed the trustee, he wanted to buy this property off my mate who's a solicitor, actually.
Right,
and he got this letter from the other guy, and he went, okay, this is an old fuddy-duddy solicitor from out Whoop, I can see this is going to happen. And he said no.
Okay. So what is it? That's a good question. So what does everyone else think? If a beneficiary of a trust says to the trustee, I want you to do this, can the trustee refuse to follow that direction?
I thought the trustee had to, was obliged to, once the beneficiary calls on that, I thought they were obliged to, give them the money for whatever they wanted, if it's a fair thing under the trust.
I think, I might be wrong, but I think Grant's question's a bit different.
Yeah, aren't they supposed to act in the best interest of the beneficiary? So this trustee might have been appointed to assist the young fellow with his money until he ascertains the age of 25, and the trustee might determine this property purchase is not worth the amount of money, so no, you're not going to get it.
I think that's much more the way I'm thinking about it, Linda, and I think Tamara's nodding. So I guess a situation might be that a person sets up a protective trust for a child, keep the money in trust, invest it wisely until that person turns 25 years, and then the money or the property can be transferred. In those circumstances, if a trustee says to the beneficiary, no, I don't think we should spend $80,000 of your $100,000 on a roadster, a motorbike, a motor car, I think we should invest it in shares and cash and term deposits. That's probably a sensible decision, as opposed to accepting the direction of the beneficiary to do things in a certain way. So coming back to your question, Grant, I think ultimately it is up to the trustee, although it does depend on the trust terms, to make a decision that is best practice in their particular circumstances. But you may get that situation. Grant?
So if they,
John, sorry.
Can they do it often? Sorry, John. How often can he do that? And just on what you just quickly said then, what if the trustee said, no, we should put it into this and this, and he led him into a share or something and they lost everything?
But
then
isn't
what?
that the beneficiary can go, well, you've led me down the garden path, so I'm going to go to court and sue you, basically. And I think that's where, Grant, when you're asking like how many times can a trustee go no to something that the beneficiary wants to buy or invest their money in, I suppose they can sort of perhaps go to court and saying, well, you're continually stopping me from utilising funds that I'm entitled to. At what point, is it going to be okay for you to agree to something that I want to purchase, I suppose?
Yep. So I think it can go both ways. I think the trustee is entitled to stand his or her its ground and say, I'm the one that is required to make the decision and this is the decision I make. However, that doesn't mean that the beneficiary is precluded from claiming damages as a result of poor decision making or inappropriate decision making, or decision making that's motivated by the wrong reasons, such as bias or personal interest or gain. So it can work both ways. B suggests, and I think this is right, according to a prudent business person, but it does depend on the terms of the trust, as I think Vivian said. So thank you, Vivian. All right, but thank you, Grant.
That gets back into, if a trustee doesn't do the right thing, that gets back into the reading for this week about can you sue them? And there's still a lot of debate around, well, should they have to pay damages or can it be claimed out of the trust?
Mm-hmm. That's right.
So that opens up a whole new can of worms, really, doesn't it?
It does, yes. And there's that those indemnity provisions in Hardun and Belilios that are relevant in those circumstances. And later in the course, we will talk about remedies, and that will be one of the issues that we talk about. I'm not sure if we've specifically answered your question, Grant, but we will come back to that during the course and there'll be more discussion about that.
Thanks.
Okay. All right. So thank you, Erin, for finding that definition, which I overlooked when I was preparing. So we get the idea that if you've got an interest in a trust, and it's very widely defined, you can apply to the court and seek an order. I mentioned, there is an issue in relation to what type of application can be made. And if we look at subsection 2 of the section 8, it says, an order of the court shall not disturb any distribution of trust property made without breach of trust before the trustee became aware of the making of the application to a court. So what that says to me is this: if a trustee acts in accordance with the terms of the trust, has not breached the trust, but has made a distribution of the trust property before becoming aware of this application to court, then the order of the court shall not disturb that distribution that was made. That's if it's made without breach of trust. And also the order of the court is not to affect any right acquired by a person in good faith for valuable consideration. What does that mean? What's that? An order of the court will not affect a right acquired by a person in good faith for valuable consideration.
Is that where they, like the trust property may have been sold to somebody and they've given consideration for the purchase, so the court can't disrupt that sale that took place?
Exactly. If we look at the converse of that situation, if the third party was complicit in the breach of trust, then they may be brought into the proceedings. And in fact, subsection 3 of section 8 provides specifically that in appropriate circumstances, the court may direct that a person be made a party to the proceedings. So be aware of that circumstance as well. Courts also have the power to determine facts or give directions. So it's very wide-ranging. There's a case of Jarks against Public Trustee of Queensland. It's a decision of Justice Margaret Wilson. It's 2008 QSC 108, and Her Honour said that Section 8 of the Trusts Act does not contemplate a wide-ranging review of the administration of a trust estate, but rather a review of particular acts, omissions or decisions. So it's meant to be, the parties were Jarks, JACQUES, against PTQ, Public Trustee Queensland, 2008 QSC 108. Okay. All right. We're running out of time, but in terms of appointment of trustees, have a look at section 10 of the Act, and that applies in circumstances where it may be contrary to what's in the trust instrument. And that's one of those examples where I said in Queensland, it's different to the normal circumstance. But generally, the trust deed provides for the power of appointment. What do we mean by the power of appointment?
Well, the sort of settler to have someone appointed as trustee, like sort of from the trust instrument, or if that trustee can't sort of like fulfil their role, for the power for another person to be sort of put in their place, basically.
Yes, that's good. That's good.
Is that section 12, John, you're looking for?
Have you got section 12? Is that Erin? Yep.
Yeah.
So section 12?
Yeah.
So section 12,
section 12
deals with, so section 12 is the statutory appointment of trustees.
Yeah.
But before we get to section 12, even though I've said section 10 means that the Act overrules the deed of trust, just be aware that typically in a trust deed, when established, the document will provide for someone to have power of appointment. It's a very important role. The person with power of appointment has the power to dismiss a trustee and replace that trustee with someone else. So that's what we mean by the power of appointment. But you're right, Erin, section 12 of the Act provides that there is a statutory appointment of trustees in circumstances where a trustee is dead or is out of the state, is discharged, unable to act, incapable, unfit, or is an infant. So then the person who is nominated for the purpose of appointing new trustees has the ability to appoint someone else to that task. So there are really three ways that someone can be appointed. in the sense that, firstly, the deed of itself may say you've got power of appointment. The second is that there is the statutory provision. So even though that supersedes what's in the deed, realistically, we'll rely on the statute in circumstances where there's a void in the deed. That's in practice. And the third option is to go to court and get a court order for the appointment of a new trustee. And if you do go to court and you ask for a new trustee to be appointed, bear in mind that there is an inherent jurisdiction in the courts to appoint a new trustee. Remember that maxim of trust law, a trust will not fail for want of a trustee. It's an old equitable principle. So what that means is that in its equitable jurisdiction, courts have inherent power to make that order. But they also have specific statutory power, that's Section 80 of the Trusts Act. So have a look at that. And in particular, Section 81 says the court may, whenever it's expedient to appoint a new trustee, and make an order appointing a new trustee, and they may do so in other circumstances. But the court also has power, perhaps under the Succession Act, to appoint a new trustee. Have a look at Section 6. In particular, Section 6, subsection 4. That was relied upon in a case called Williams against Williams, 2004 QSC 269. And Section 52, subsection 2 of the Succession Act might be something you could consider as well, relying upon in those circumstances.
John,
Yes.
did I read and understand correctly that when a settler is setting up a trust, they may put in the deed what happens if the trustee dies or can't be found or all those things that the Act mentions?
Yep.
They can actually dictate what happens in that situation?
Yes. So the settlor can express certain provisions about the way in which people are appointed in that regard. Have a look at, is it Tatham and Huxtable is the old principle in that case. It's a very old case. I think that was the decision that I'm thinking of in that regard. But certainly you're right. The deed of appointment, the deed of trust, will often provide for the power of appointment, and that power of appointment can be limited, or it can be, there's certain directions made in relation to it.
John, just furthering on from that, whether it's a question or not, I don't really know. But so, like tonight, we've spoken a lot about the Trusts Act and the Succession Act, and then, like in the readings, it spoke a fair bit, probably more so in regards to like disputes over trusts and things like that. Spoke a lot about courts looking to the nature of the trust, what it contains, what's been expressed, what's implied, who are the trustees, who are the beneficiaries, what they stand to gain, what they don't, and so on and so forth. So, like we all know that in a way, statute trumps common law, but how much are courts guided by statute when it comes to sort of focusing on like the trust instrument itself and sort of going, well, this is what the settler wanted, so that's what they're going to get, even if statute might say something different. Does that make any sort of sense anyway?
No, that's a really good observation and a very good question. The Trusts Act will supersede, in most instances, what is mentioned in the Act, theoretically. However, courts are very cautious. They're very reluctant to act, and they're particularly reluctant to act against the desire of the settlor. So the settlor's intentions will always be extremely relevant. And when it comes to, for example, appointing a new trustee, the courts do have the power to make the new appointment, but they'll only do so where it's expedient to do so. And again, they'll be very cautious in that regard. So the same principles apply in terms of the extent to which the courts are willing to intervene. And the answer is, I guess, reluctantly, cautiously, very carefully. And to give you an example of that, have a look at Section 80, subsection 1 of the Trusts Act. And that deals with the issue of expediency when considering the statutory appointment or the appointment of a new trustee. the courts do have the power, but they'll only do so in circumstances where it's in the interest of the beneficiary to do so. Have a look at a High Court case. It's an old one, but Miller against Cameron, it's 1936, 54 CLR 572, and that gives you an idea of what is regarded by the courts as a satisfactory execution of obligations. And it also discusses the issue of welfare of beneficiaries, because that will always be the dominant consideration for the court when they're considering appointing or removing a trustee. That's a very old principle. That goes right back to re Tempest from, I don't know, about 1850 or something.
John, how do the courts decide on who to appoint for a trustee? Do they have certain organisations that they can go to, or what's that process, and how do they determine it?
Yeah, well, I guess they'll factor in a few different things. One thing that they'll consider is, all right, we talked about this, Tamara alluded to it, what did the settlor wish in terms of appointment of a trustee? I mean, they're not normally going to appoint a trustee unless they represent the interests of all the beneficiaries. So courts are reluctant to appoint a beneficiary. They're also reluctant to appoint someone closely associated to a beneficiary. And the reason for that is that that candidate is seen as being biased or potentially biased. And also the court will consider whether a person is willing and able to promote the reasons why the trust was established in the first instance. Now, I think someone, Vivian and Maria, said public trustee, and often that will be the case. Often the public trustee will be appointed. It doesn't have to be the public trustee. There are other commercial trustees, but generally the public trustee. And also have a look at the Corporations Act, Section 601 TAA. It goes on from there, but that generally talks about trustee companies, their special skills, and it also gives them a reason why they're entitled to charge for their work. And Grant's just put up... Yes, Grant?
I just put up it was in the Australian last week, Justice Michael Pembroke. He's becoming very well known for not letting feckless children come and get their inheritance off their parents when they're 50 and 60. And he did another case the other day, and that was the article where he says, don't just walk into my court thinking you're entitled to money. And it's about the third or fourth case in the last year. He's really putting his foot down on it. So
that sounds excellent. I love that. Feckless heirs. That would be a good one to put on you, crew, but thank you, Grant. And while you were mentioning that, Vivian mentioned the adult guardian prefers public trustee, and that's true, although a couple of things. We call them the public guardian now, not the adult guardian. And those appointments of the public trustee to act as administrator for individuals who lack capacity, that's done through the Queensland Civil and Administrative Tribunal. It makes a lie of me saying the Supreme Court, doesn't it? But that's under the Powers of Attorney Act. It's a different piece of legislation. Oh, I've done it again. We've run out of time. I'm sorry. Trust law is interesting. Hey, any last comments or questions? Because I've got people online for evidence. Okay.
The questions are too long, but the only comment I can say is that Gina Reinhardt seems to figure a lot. She must supply lawyers with a lot of jobs in trust and equity. Yes,
absolutely. And look, if you haven't had a look at it, have a look at that case of Porteous against Reinhardt. It was 1998, 19 WAR 495. So have a look at that case. Have a look at Miller and Cameron. Definitely look at the issues to do with the Trust Act. And I'm sorry we didn't get fully through it, but your text is excellent and you've all read it much more carefully than I have anyway. So that's all good news. Okay, I'd better wrap it up and we'll see you on Crew. It's a break week next week. So don't come online next week. We'll see you in 2 weeks' time. Okay, all the best. Bye.